purpose of a statement of claim, starting a lawsuit. When you are looking to start a lawsuit, whether on your own or through a lawyer, it is always worthwhile to understand each of the steps in the court litigation and the purpose of each of the court pleadings that are filed with the court. The initial court pleading that initiates one's lawsuit in most Canadian jurisdictions is a statement of claim, which is the originating pleading that sets out the basis for proceeding with one's lawsuit. The central purpose of the statement of claim has been described by the Canadian judiciary as comprising three central facets: to 1. Identify and set out the issues to be tried with clarity and precision; 2. Give the opposing parties fair notice of the case to be met; and 3. To enable all parties to take effective steps for pretrial preparation. Furthermore, the Canadian judiciary has frequently explained the purpose of a statement of claim by citing the scholarly text of I.H. Jacob, Bullen, and Leake, and Jacob's Precedents of Pleadings, which explains a statement of claim as follows. The statement of claim constitutes the document in which the plaintiff formulates the factual grounds on which he bases his claim or the relief or remedy which he seeks against the defendant. The statement of claim must state in summary form the material facts on which the plaintiff relies for his claim. It is not enough, however, for the statement of claim merely to state the material facts and to claim specific relief or remedy. There must be an interconnection, a legal nexus, between the facts relied on and the relief or remedy claimed. The material facts relied on must disclose a reasonable cause of action against the defendant. Otherwise, the statement of claim is liable to be struck out precisely on the ground that it does not disclose a reasonable cause of action. The statement of claim must show, on the basis of the material facts alleged, a viable legal and enforceable claim against the defendants. The basic function of the statement of claim is therefore to state in summary form the material facts on which the plaintiff relies, which together constitute a cause of action entitling the plaintiff to the relief or remedy claimed. It is, of course, also the function of the statement of claim to state such material facts to enable the defendant to know the case that he has to meet, but its central purpose is to formulate a cause of action against the defendant. With this scholarly text also providing an important explanation as to the meaning of a cause of action as follows. A cause of action has been defined as being every fact which it would be necessary for the plaintiff to prove, if traversed, in order to support his right to the judgment of the court. It does not comprise every piece of evidence which is necessary to prove each fact, but every fact which is necessary to be proved, or perhaps more accurately as being simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. As to the presentation of facts in the statement of claim, as Justice Dunlop wrote, quote, if a specific fact is not set out, but can be properly inferred from other statements in the pleadings, that is sufficient for the purposes of a statement of claim, end quote. What one seeks to avoid is a scenario that faced Justice K. Smith in Homalco Indian Band v. British Columbia. In my view, the statement of claim is an embarrassing pleading. It contains much that appears to be unnecessary. As well, it is constructed in a manner calculated to confuse the defendants and to make it extremely difficult, if not impossible, to answer. As a result, it is prejudicial. Any attempt to reform it by striking out portions and by amending other portions is likely to result in more confusion as to the real issues. Instead, one should look at Justice Smith's instructional directions as to how statements of claim and other court pleadings should in fact be drafted. The ultimate function of pleadings is to clearly define the issues of fact and law to be determined by the court. The issues must be defined for each cause of action relied upon by the plaintiff. That process is begun by the plaintiff stating for each cause the material facts, that is, those facts necessary for the purpose of formulating a complete cause of action. And as with almost every legal proceeding, the particular facts and circumstances of the case will have such great impact on how the matter is to proceed and how the court pleadings need to be drafted. For even though the words of Supreme Court of Canada Justice Binney in Whitten versus Pilot Insurance Company states, one of the purposes of a statement of claim is to alert the defendant to the case it has to meet. And if at the end of the day the defendant is surprised by an award against it that is a multiple of what it thought was the amount in issue, there is an obvious unfairness. Those very words need to be taken in appropriate context. For where the defendants concealed and deceived the plaintiffs, and it is the defendants alone that have control and access of the material evidence, which will fully elucidate the scope and depth of their wrongdoing, together with the damages arising therefrom. That is not something that can be expected of the plaintiff to plead at the outset of the court action in its statement of claim. Thank you.